This judge didn't raise his voice. He didn't hesitate. There was no warning. But with just 3 words, a legal career that took decades to build came crashing down in seconds. The courtroom went silent. The defense froze. And what happened next shocked everyone in the room. Because bail was expected. Routine. Almost guaranteed. Instead, the judge looked down at the file, paused briefly, and said words no one was prepared to hear. Bail is denied. Gasps rippled through the courtroom. The defendant didn't move. And within moments, court marshals stepped forward. To understand why this moment was so shocking, you need to understand how rare decisions like this really are. In most high-profile cases, especially those involving experienced legal professionals, bail hearings are often procedural. Lawyers prepare their arguments. Judges listen. And unless there is a clear and immediate danger, bail is usually granted. That's why nearly everyone in the courtroom that day believed the hearing would last no more than a few minutes. The defense team appeared confident. The prosecution looked calm. Even spectators sensed this was going to be routine. But what most people didn't know was that the judge had spent hours the night before reviewing something very specific. Not a headline, not a rumor, but official court records. Records that painted a very different picture. The defendant was not unfamiliar with the legal system. This was someone who had spent years navigating courtrooms, understanding procedures, and building credibility. A person with a reputation, a professional image, and influence. Many believed that reputation alone would carry significant weight in the judge's decision. But according to court documents, there were inconsistencies that could no longer be ignored. Statements that didn't align with earlier testimony. Documents that raised serious questions. And timelines that simply did not match. Individually, none of these issues seemed fatal. But together, they formed a pattern. A pattern the judge could not overlook. As the hearing progressed, the defense presented arguments that sounded polished and familiar. They emphasized cooperation. They cited prior appearances. They referenced professional standing. It was everything the court had heard countless times before. But when it was the judge's turn to speak, the tone changed. The judge didn't interrupt, didn't argue, didn't debate. Instead, he calmly explained that bail is not a right. It is a privilege, and that privilege depends entirely on trust. Trust that the defendant will comply with the court. Trust that evidence will not be interfered with. Trust that the process will be respected. And according to the record before him, that trust had been broken. The judge referenced communications that raised concerns, actions that suggested possible interference, and behavior that, while not yet ruled upon, could not be dismissed. This wasn't about punishment. It wasn't about public pressure. And it wasn't about making an example. It was about risk. The judge made it clear that when risk enters the equation, the court must act cautiously. And then came the words that changed everything. Bail is denied. In that moment, the weight of the decision settled over the room. The defendant's expression shifted. The defense team exchanged glances. And the spectators leaned forward. Because this wasn't just about detention. It was about consequences. Without bail, everything changes. Careers pause. Reputations suffer. And legal strategies collapse. For someone whose life revolved around the courtroom, being led away by marshals was more than symbolic. It was devastating. Court officers approached. The defendant complied. And just like that, the hearing was over. But the impact was only beginning. Outside the courtroom, reactions spread quickly. Legal analysts questioned what this meant for the case. Commentators debated whether the decision would influence future proceedings. Some called it overdue accountability. Others called it excessive caution. But one thing was clear. This decision sent a message. That status does not guarantee protection. That experience does not equal immunity. And that the courtroom, at its core, still answers to evidence and risk. In the days that followed, attention turned to what would happen next. Without bail, the defense faced significant challenges. Access to resources became limited. Preparation became harder. And public perception shifted. Every move was now scrutinized. Every statement examined. And while the case itself was far from over, the denial of bail had already altered its trajectory. Because in the legal world, momentum matters. And that momentum had shifted dramatically. For the judge, the decision was not emotional. It was procedural, based on records, based on behavior, based on responsibility. And while critics argued, the court stood firm. Bail decisions are not about sympathy. They are about safeguarding the process. And in this case, the process demanded caution. As the courtroom emptied, the gravity of the moment lingered. A reminder that no matter how familiar someone is with the system does not bend for anyone. 3 words. No bail granted. And just like that, everything changed. That made this decision even more unsettling was how calm the judge remained. There was no anger, no frustration, no grand speech, just facts. The judge explained that when the court sees patterns that suggest disregard for procedure, it has an obligation to act early, not later. Waiting would have been easier. Granting bail would have been expected. But easy does not always mean correct. The court emphasized that the decision was not a judgment of guilt. It was a judgment of risk. And risk, once identified, cannot be ignored simply because the defendant is respected or well known. That distinction mattered. Because within hours, headlines began to blur the difference. Some reports framed the decision as a downfall. Others called it a warning shot. But inside the courtroom, the meaning was very specific. This was about control. Control of the process. Control of evidence. Control of what happens next. When bail is denied, it changes the balance of power. The prosecution gains leverage. The defense loses flexibility. And the court maintains authority. Legal experts later pointed out that judges rarely make decisions like this without extensive documentation. Nothing is impulsive. Nothing is rushed. Every word spoken from the bench is calculated. Which is why many believe the judge saw something most people still haven't. Something buried in timelines. In communication logs. In procedural gaps. Not dramatic enough for headlines, but serious enough for concern. As the defendant was escorted away, there was no resistance. No protest. Just silence. And silence, in moments like that, speaks loudly. Outside the courthouse, speculation grew. Would new charges fall? Would additional evidence surface? Would this decision pressure a plea? Those questions remained unanswered. But one thing was already clear. The narrative had changed. What began as a manageable legal challenge had become something far more serious. And once that shift happens, it's almost impossible to reverse. Days later, analysts revisited the judge's wording. Not the denial itself, but the reasoning. Phrases about responsibility. About safeguarding integrity. About protecting the process. These are not phrases used lightly. They are signals. Signals that the court is watching closely. Signals that future actions will be measured against a higher standard. For the defense, this meant recalculating everything. Strategy. Timing. Public response. Every move now carried greater weight. Because when bail is denied, the court is no longer waiting to be convinced. It is waiting to be reassured. And reassurance is harder to earn than permission. As more details emerged, it became evident that this was not a single-moment decision. It was the result of accumulation. Small concerns adding up. Minor inconsistencies stacking together. Patterns forming quietly over time. That's often how careers end in the legal world. Not with a scandal. Not with a dramatic confession. But with patterns. Patterns that, once seen, cannot be unseen. And judges, more than anyone, are trained to recognize them. In the end, this case became a reminder that the courtroom is not impressed by reputation, not swayed by confidence, not softened by familiarity. It responds to evidence, to behavior, to risk. And when those elements cross a certain line, the response is swift. 3 words. No bail granted. Not shouted. Not emphasized. Simply stated. And in that simplicity, everything changed.